Such a beautiful morning, and I am happy to be here. I would like to know how excited or happy we had to be here today. Are we happy to be here? Thank you. And I'm just so grateful and filled with so much gratitude to the Almighty God for the privilege to have a physical conference again this year. I mean, the last time we had a physical conference was in 2020, and thanks to COVID, we were able to have a virtual conference last year. So I would like us to give a round of applause for ourselves for being here today. Thank you so much. I must appreciate and salute my Master, God Almighty, for the privilege given to me to host this conference year in, year out since 2019 when I got the instruction to start a free conference for lawyers. And so I would say to my Heavenly Father, thank you. And I also want to say thank you to every one of you who has showed up year in, year out every year. If you have been here since the inception of this conference, can I see a show of hands? Fantastic. Awesome. 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 Well, do we have members of Strictly Law Business Community here? Oh, nice, nice. Welcome, everyone. Special appreciation to all our panelists, our moderators, our keynote speaker, the indefatigable NBA president, Mr. Olumide Akpata. Thank you so much. It's been my desire for us to have a sitting NBA president grace our conference since we started. And I'm so grateful that that desire has manifested this year. Thank you so much. I really appreciate the fact that you took time out of your busy schedule to be here today. Thank you so much for honoring us. My Lord, the Chief Judge of Ogun State, thank you so much for coming all the way for this conference. Thank you so much. We appreciate. And I am so, so grateful to all our moderators and panelists. Thank you so much. We appreciate your patience. Thank you so much. And a million thanks to our sponsors, our donors, and our partners for helping us to host this conference every year. I mean, we've leveraged and relied on the sponsorship, support, and donations we get. And that's why we're able to make this a free one for us. Thank you so much. Before us today is a very interesting conversation, and we're going to be talking about technology. And while it is not a new subject matter, but I think it is still very important for us to have the conversation. It is very important for us to address the conversation from the different aspects wherein we have divided the theme of this conference. But before I go into that, I'd like to make a few comments about the state of our industry, our roles, and the necessary changes that we urgently need to make happen within our society. But before I go on, I would like you to play the voice notes. And I would want us to listen carefully to this voice notes because when I listened to that voice note, it struck a lot of chord within me. It was disheartening for me, and at the same time, it was a wake-up call for us, particularly as lawyers, most especially as young lawyers, the category in which I fall into. Okay, I'll just proceed while we wait for them to bring it on later. I'll start with my constituency, the young lawyers. I think it is time for us to stop, the necessary social media rants, complaining about what is working and what is not working within the society, particularly within our industry. Oftentimes, we get a lot of messages sent to us saying, "Strictly Lobbies, have you seen this? Have you seen that?" We are on the rant again. I think that rather than complaining about what is not working for us as young lawyers, we should begin to think about how we can make things work. What we need to do to make this industry better. What we need to do to make this industry, to keep raising the bar of this industry. But most times when we go into the ranting mode and we keep complaining, what we are doing is we debase the nobility of our profession. And we can't keep doing that because we need to have a good, positive projection for our industry. The fact that we go on social media, particularly for us as Twitter lawyers, ranting, we're laughing, we know, ranting and complaining, I totally understand that sometimes the situation is not very favorable to us. But I think that beyond just complaining, we can use what we have. I mean, and that's the power of technology, which we're talking about today. You can set up your law practice. You can do a whole lot of fantastic things rather than complaining about what is not working. And, I want to implore us to desist from the social media rant. a lot of people have not been able to, we have not been able to monetize the potentials of our industry. Because when you say that you are being paid 15,000 naira as a lawyer, young lawyer, and then you're charging another client 150,000 or 500,000, nobody's going to pay that amount. Nobody's going to be willing to pay you that amount. So I think we have to desist from complaining. We have to begin to think of creative ways to create our own table, to create sustainable and creative solutions for our industry. And in similar vein also, I'd like to also respectfully appeal to our elders, our seniors, to deal more kindly with the younger lawyers. Most times, a lot of us are still coming up and still trying to find our footing, and so we are bound to make mistakes. We are bound to go the other way. But I want to appeal to us that we should deal more kindly with the young lawyers. And while it is true that we may have taken years as senior lawyers, years of toil, years of struggle to get to where we are now, but I think we also need to know that those coming behind us or those coming behind you do not necessarily have to engage in those years of struggle, those years of toil, those years of torment for them to be able to get it right. I mean, with the technology, with the advancement of technology and we're leveraging on technology, it is very easy for young lawyers to break through in 5 years. So I want to implore us as our elders to kindly let's change the narrative. The narrative of, oh, I toiled for 5 years. My managing partner, my boss did not treat me well. And so I have to, do same. I think we should, move away from that narrative and begin to look for how we can do better and how we can also help we as young lawyers to also do better. I mean, it should be from glory to glory. It should keep getting better and better. We shouldn't not necessarily keep selling that narrative of I struggled, I toiled for years, and so you also have to go through it before you break through. People can break through without going through that years of struggle. So I just want to employ us as, collectively as our industry to begin to raise the bar and let's look for creative ways not to okay, so the word I want to use is let us desist from debasing the nobility of this profession. Let us desist from debasing the nobility of the profession, because the way we project ourselves is the way we are valued. It is the way we are perceived. It is the way we are responded to. And it is the way our briefs would also be responded to. So I just want to use this medium to say, as much as there are a lot of challenges, and which I totally agree, every industry, every profession have their own challenges. It's not peculiar to just the legal industry, but let us stop washing our dirty linen outside. We can come together to have a dialogue and see how we can move the profession forward without necessarily going to the social media space to rant. And I also want to employ I'm calling and employing on all our legal bloggers that we should please use our platform to amplify the good within this industry. Let us use our legal blog, our platform, to amplify the good within this industry and not necessarily amplifying the things that would debase the nobility of our profession. This profession is very noble. This profession is very profitable. But we need to join hands together to ensure that we guard against the forces that are trying to infiltrate our industry. We need to come together and ensure that we mount roadblocks against those other people trying to infiltrate into our profession. But the only way we can do that is to ensure that we are not projecting ourselves as poverty-stricken lawyers. We are not projecting ourselves as people without value. We are projecting ourselves as valuable people, as people without which the society cannot exist, without which businesses cannot exist, without which businesses cannot succeed. So we need to understand our value and we keep reinforcing our values. It is not, it's not cheap to go to law school, and we all understand all the process we've gone through, the rigors we've gone through. So we need to stop debasing the nobility of this profession. Because I want us to listen to this voice note, because it came from my inner circle friends, and it touched the core of me, because in that inner circle, I'm the only lawyer there. And so I felt like I was attacked. because they said, who are the lawyers in this space? What are they doing? Every day we hear about the startup space and the things you need to do, how you can raise money, but we do not see, people do not have regular conversations about law. Please, can we play it? I want us to hear it from the horse's mouth. Because the person was so, I was embittered.
And I was, with a lawyer yesterday, right? Busola would know her, right? And we're just talking about, how several things has really been democratized in that legal value chain. So lawyers now have to really up their ante, cause with the whole technology coming in with so much force, right? It means that some things that only a lawyer could really get you, you might not get that thing without the services necessarily of a lawyer. So really, beyond just that falls around, you need a lawyer only for this. How can lawyer begin to position themselves, right? Can lawyers begin to look at, in medicine, there's what we call preventive medicine, curative medicine, right? So can lawyers begin to position themselves as preventive entities, right? Like preventive law, preventive entities, such not because people look at legal people as curative people, which is if I get into a problem, I'll just go and get a lawyer. A lawyer is when I get into a problem, right? So there's been a lot of, and that's why people don't see any need for a lawyer till they get into a problem. So I think, Busola, the business of law should also begin to focus on that shift where lawyers are not now fighting technology. So lawyers are not now angry because, so people can now do many things without need of a lawyer. Even registering a company should just be one of the most least and basic stuff. In fact, it should even simplify to the extent that in 24 hours, you've incorporated. So you will not probably need a lawyer for things like maybe equity vesting, dissolution, setting up, looking for a co-founder, setting up your blah, 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 fitting your business and everything. But I just think that so many lawyers are just concentrated on, and what's going to happen is very soon, it will just be like this. Do I want to put it now? Like even drafting of contracts and all those things, and it will just get very democratized. So I think lawyers need to up their ante. What is really the essence? What is the business of lawyers, right? Beyond just when I get into trouble, then I call my lawyer. How can lawyers begin to collaborate and, what's it called now? Begin to support the system? Because once the system begins to get simplified, lawyers lose their relevance. So lawyers' relevance is in the complication of the system, right? So once the system begins to get very simplified and easy with technology, right, it removes why am I talking like that? It removes a lot of that friction. So Busola, I think we need to latch into that space. How can lawyers see this, right? As no, we're not angry that you can now register your business, you can now do a contract, you can now do this. How can lawyers step in, right, and collaborate with that? I'm just modeling up a lot of things, but I'm just saying that there's just got to be some form of value in all of this, right? 18K, 70K, that's really far apart, right? So
thank you.
That's for you, Busola.
That's enough. And that's coming from a layman, an unlearned person. And I think that's just the voice of many other people within the society, the expectations they have of us as lawyers. Let us refrain from belittling ourselves. You may not be earning well today, but what can you do? How can we invest in your professional and personal development, particularly we that we are young lawyers? We still have all the energy. We still have all the strength. This is the time to work. Complaining, ranting will get us nowhere. We need to move. The world is waiting for us. Businesses are waiting for us. They need sound lawyers. They need smart lawyers. They need lawyers who they can feel comfortable with. But when we go ranting and describing the way we are treated, and even if we are treated that way, I really do not subscribe to us being treated that way. But there is some sort of value, some sort of gain in it. Because in life, there is no, without pain, then there may be no gain. I've been in a very toxic environment, in a very toxic employment. But there were so many lessons that I've taken from those situations. They weren't pleasurable, they weren't beautiful. But in it also, there are a lot of lessons. So rather than focusing on the pain, can we begin to focus on the gains that we can get when we look beyond just CSC registration? CSC, like my friend said, shouldn't even be what, and I say that most of the time, that is what a lot of us as lawyers begin to project. Those are the things we sell, but beyond that, there are a whole lot of other things we can do. I think we just need to put on our creative thinking cap so that we can begin to see and identify gaps wherein we can provide solutions. And it is in that way, in that regard, we'll be able to get enough value, and then would also be valued. And when you are valued and seen as a person of value, by the time you slam your fees on the client, they'll be willing to pay. I met someone who is not a lawyer recently, and he said, "Oh, thank God I'm meeting you, Busola, because you're a lawyer." Lawyers are really expensive. You guys are expensive, but we do not see ourselves that way. That's how the public see us. Can we begin to see ourselves that way? Can we begin to project ourselves that way? And so that we keep honoring the nobility of this profession. On this note, I'd like to welcome every one of us to the 4th edition of the Business of Law Conference.
My Lord, the Chief Judge of Ogun State, always a pleasure to see you, my Lord, and maybe I should take the opportunity to thank you again. The December 2021 event that Busola just referred to, as you all may know, happened in Abeokuta, where we had our NEC meeting, and my Lord and the Ogun State, with the Ogun State government, played such a fantastic role in welcoming the bar to Abeokuta. And I thank you, my Lord, again for your support for the bar. Learned senior advocates here present. I notice Chief Joe Kiari Gazama, SAN. I notice my big brother and friend Yemi Kandi Johnson. I noticed I was sitting right next to Folabi Kuti, our brand freshly minted senior advocate from the Lagos bar. Still until the next class comes. I am not so sure who is on the other side of the hall, but I want to just welcome our learned senior advocates for whom we have the highest regard. Distinguished ladies and gentlemen, members of the press. Of course, I see a lot of my members of my group, the Young Lawyers Forum of the MBA, the Young Lawyers. I welcome you. Time is fast spent. On your behalf, I will firstly apologize to my Lord for us kicking off later than advertised. Maybe you should have indicated that 9 a.m. was for registration, and that start-off was actually going to be 10. So on your behalf, I apologize to my Lord, because my Lord was here before 9 a.m. So I thank you, my Lord, for your patience. My Lord, I know you stayed back because this is a very important subject we want to interrogate today, and your presence will definitely lend gravitas to the conversation. And I thank you for staying back. I am delighted to be here. I am glad finally that the opportunity has come, and I must commend Busola for, if nothing else, her tenacity that her size does not even indicate she possesses. She will not let you be. So, but that quality and that trait is necessary, it's required. in the profession that we practice. Tenacity and without being offensive, just applying gentle pressure. That's what Busola seems to know how to do, and that has eventually brought me here today. And so keep it up, and continue to do what you do. The sky is your limit, Busola. And then it was also important for me to be here, not just because of Busola's insistence, but also because of the topic that you have chosen for this particular edition of the conference, and because technology is I can't even say it's so important. I mean, that's stating the obvious. One of the problems I find in our profession is that lawyers are still talking about technology as if it's an option. So that's the problem I identify. It is not an option. It is almost, you can almost equate technology to oxygen. And without oxygen, you know what will happen to your business. It will atrophy and it will die. So I just wonder sometimes how come lawyers haven't actually gotten the sense that they really have no choice. We really have no choice in the matter. But of all the professions, I think the legal profession is the laggard as far as adapting or embracing technology is concerned. Look at or let's say the legal services sector. Look at the banks. We were all here when they started, and today, I tell you, Nigerian banks. I have friends who call me from the Middle East, who call me from other countries and say, I mean, friends who live here and also live in other countries, they say our banking sector, as far as technology is concerned, is top notch. It happened before our very eyes. But you find out that even to get our lawyers to pay bar practicing fee online is a debate. One senior lawyer, J.S. Okutekpa, has even petitioned me to the Chief Justice of Nigeria for asking that we pay our bar practicing fee online. It is ridiculous. Senior Advocate of Nigeria, he wrote a 6-page letter to the CJN. We have tried to explain to him that the money is still going to the bar practicing fee Supreme Court account. But he would not listen. He has asked the CJN that he was not paying until they explain to him why. Some have written that we want to go back to Egypt. We want to queue in the bank. We want to stand in line and queue in the bank. It's just, and I'm wondering to myself, do they really understand what we're up against without technology? To pay bar practicing fee online. Technology comes with its hitches, as we experience today, but you deal with it and you move on, because technology is life. Life comes with its hitches. And then somebody is telling me, no, we don't want to pay online. Stop this nonsense, it's just so annoying. I say, you rather go to the bank and fill teller and count the money. Meanwhile, in 3 minutes in your bedroom, you can fix it. It just tells you the mindset. And I'm glad that we have with us today Rotimi Ogunyemi. Rotimi, please stand up. I know you don't like this, but Rotimi is the co-chair of our digital MBA committee. And if we are making any strides as far as tech is concerned in the profession, it is as a result of the help that Rotimi and his chairman, Basil Udotai, continue to provide, the advice that they give. And what I have said is that whether we like it or not, I am going to drag this profession kicking and screaming into the technology, into the digital space. We are going to become digital natives. There's no other option. And truth be told, it will be odd if Oluwakwata exits MBA presidency without doing that. It will be odd, because I know it is expected of me. Now, digital MBA, watch this space. We're going to be launching the digital MBA April or May. We're working on it. We're moving the MBA, because I've been president now for close to 18 months or thereabouts, or 16 months or whatever. I have been part of the call to bar of about bar ceremonies. We have admitted about 10,000 new entrants in the short space of my being president. 10,000 new entrants, all of them digital natives, at least the majority of them. Meanwhile, the association is not speaking their language. How can they feel like if they're a part of the NBA? They speak a certain language. They live on they're on their device, but the NBA is not there. We are still asking you to fill this form, take it to your branch, wait for the reply. And I've told the people at the NBA, you will lose your membership. Many of us know that I said that in the run to the election, I said 7 out of 10 lawyers will tell me, what does the NBA do for me? And we said we want to answer that question. We want to make sure that by the time I leave, you can reel out what the NBA does for you. Now, when we came on board, certain elements decided to set up the Northern Nigeria, the New Nigeria Bar Association. And everybody was screaming, oh, how can they, how dare they? And I said, how dare they not? If you make the grass green, the sheep will come to pasture, right? So it should never cross the mind of it would never cross the mind of a satisfied member of the association to go to another or form another body, right? So even if we knew that there were some political undertones, but there were some people, apolitical, who just felt, all I do here is pay my practicing fee. Nothing really happens. So we said we have to change that narrative. And if 10,000 or 5,000 are joining the profession every year of a certain demographic who live and breathe technology, and then the association that they belong to, right, is resistant to technology, then you find that we're working across problems. There's obviously going to be collision. And so Rotimi, Basil, and a team of others are working with us to ensure that we move into that digital space. The NBA app, our USSD code, that ecosystem where we are having our online community and all of that. You can be sure that before I leave the stage, all of that will be launched and birthed and you can participate. Hopefully, Okutekpa SAN will participate too. So that is why I'm here. That is the reason why it was important for me to be here and to join the convener and all of us here to continue to preach the message that technology is not an option. Whether it be law tech, which is technology as an enabler of legal practice, or tech law, technology as a subject matter area, it's not an option. This is the world we live in today. That is the world we live in today. And technology is, and we keep on talking about it as if it's the future. It is not, it is the present. It's just that we are in the past. It is the present, and it just is befuddling, right from those who are the policy makers. I don't understand whether there's this refusal, there's this denial. It is the present, and it's happening before our very eyes. And if we are thinking that there will be some, one big bang event to announce the arrival of technology, Wakpembe, you will wait for very long. It is happening. It is already happening. I always give the example of a driver I use in London. Now, he uses a particular Mercedes to pick me up anytime I get into London. So I got in on this trip. He was using the same Mercedes, different color. So I said to him, oh, you got a new car? He said, yes. Same shape. Nothing had changed, ostensibly. But as we drove out, he looked at me, Indian guy, said, boss, no hands. So the car was driving itself. Same shape. So if you were thinking you see one when we were growing up, Space 1999 vehicle, no, it was the same Mercedes. He said, boss, no hands. I said, really? He said, yes. He keys in my destination, my location, and he's on his way. We're on our way. He's gisting with me. And then from time to time, you hear this buzzing sound. Brr, brr. I said, what is that? He said, just in case he falls asleep. The car is just reminding him that you are still driving. I said, okay. And so we're going, and when we get into town, we get into central London. And then we were at the traffic light. And then we're ready to move, and then a cyclist beats the traffic light, and the car stops. And he says, "Boss, that wasn't me. It was the car." Sensor right in front there. All the cameras could see the cyclist. And then it just occurred to me that if I was waiting for a big bang, it is the same Mercedes, but Mercedes has already moved on. Of course, I don't need to tell you guys about Tesla and the others. But Tesla, you and I know that, okay, Tesla is a representative of new tech. But this is Mercedes. Old, conservative Mercedes. They have moved on. And we are still here. Legal services sector, we are still here. We are still pushing paper. Let me go to my speech. I hope we understand or we get the drift. My Lord, the Chief Judge of Ogun State, Dynasty Advocates, distinguished ladies and gentlemen, it is my pleasure to deliver this keynote address today to this distinguished audience on a theme that is very dear to me personally: the use of technology for the practice and business of law. As a business lawyer who has leveraged extensively on technology in my private practice, and one who has long viewed law as a business, I could not have asked for a more topical or practical theme. As some of us can attest, the Nigerian Bar Association, which I have the humble privilege of serving as president, has made giant strides in the service of its members. Service to its members. At the core of our activities and achievements has been technology. From significantly more efficient information dissemination, through payment and processing of practicing fees, to organization of events and conferences, technology has been a veritable aid to success for us. It is therefore only natural that I should jump on the opportunity to continually preach the technology gospel to our colleagues and friends. I do not propose at all that this address should sound like an academic lecture, which is why I will not attempt any grand definition of the term technology. Basically, any tool that is created out of the application. And in due course today, our distinguished panelists will examine the place of technology in the law profession from different critical angles. What I call law tech. Permit me, however, to set the tone for that discourse by reminding us generally of what technology has done and is doing already in the practice and business of law, and to agitate us on what would likely happen if we treated technology as a fiend rather than a friend. Let me start with the basic. Technology as an enabler of the lawyer's physical work product. The lawyer everywhere is a knowledge merchant who usually sells what he or she knows through the documents that he or she prepares. Advisory opinions, pleadings and memorials, contracts and conveyances, etc. As some of us may recall, there was a time that legal offices in this country relied on secretaries and typists to type out letters, pleadings, contracts, and other documents as dictated orally by lawyers, using typewriters that had little tolerance for typographical errors. As of the mid to late 90s, this was still prevalent in most law firms, which meant that efficient service delivery was invariably a challenge. Today, technology which we now almost take for granted has turned that experience around beyond what none of us could have imagined as recently as 30 years ago. Documents can be amended without having to type them all over again because they are already saved on computers. Executed documents can be stored in an electronic format and easily retrieved on demand without needing to wade through piles of dusty binders. Even the fonts in which the lawyer's written work is presented can now be pre-selected or customized. There is also technology as an aid to the lawyer's intellectual work process. I was fortunate to have qualified as a lawyer at a time when law reporting in Nigeria had already gained ground. In my early days of practice, when litigation was my source of daily bread, I was grateful that most law reports that I needed to do my work with had indexes, which made it relatively easy to find decisions that were relevant to my needs. But I did occasionally wonder at that time how the lawyers who had practiced in the days when there were either no law reports or no indexed law reports, how it must have been for them, how they must have had to devote longer times in research to find helpful decisions. Today, specialized search engines of legal research databases are proving more effective than indexes in many respects. And I realize that there may also be some young lawyers out there who now wonder how difficult it must have been for me to do manual searches of reported decisions, relying only on printed indexes. This is, of course, a very basic illustration, as there are now commercially available law tech tools that can do much more complex and diverse things, including contract reviews, some measure of independent research, etc. Of course, we all know that we have Watson and all of that. AI that will do the review of contracts for you, and with 99% precision, almost rendering the lawyer redundant. The point, however, is that incorporating technology into legal practice can radically alter even the intellectual aspect of what we do as lawyers. How about technology as the lawyer's organizational aid? As many of us know, lawyers and their diaries are historically inseparable. Daily, and certainly before any new appointments or court dates are taken, the diaries must be consulted to ensure that existing appointments are honored and potential conflicts are avoided. Now, with the help of technology, lawyers can access digital tools that can, amongst other things, record and remind them of their appointment hours, days, or weeks before they fall due, and also prompt them to record the outcome of the appointment after the due date has passed. Further, as arguably the silver lining of COVID-19, those appointments recorded in the diaries, including court sessions, could be honored on reliable virtual platforms without the lawyer having to step a foot out of his or her office. The foregoing are only a few of the uses of largely low-hanging technology in the practice of law, which we may already be familiar with. I am confident that by the time today's panels are done with us, the horizon of just how much we could potentially achieve in practice with technology will certainly be significantly broadened. Regarding the business of law, which is concerned with such matters as winning new work and retaining existing clients, being visible in the lawyer's relevant practice niche, etc., the use of technology is also even so seminal. For starters, websites have created a unique platform for overcoming some of our traditional restrictions on advertisement and solicitation by a legal practitioner. Law firms are investing in building breathtaking and user-friendly websites that can showcase their capabilities without offending the rules of professional conduct. For some clients, especially those who are not familiar with the Nigerian legal market, this is usually a good place to start when they want to choose external counsel. Professional networking sites, LinkedIn for example, also continue to serve as worthy conduits for making cross-border professional connections that sometimes lead to new instructions or work opportunities. Even in communication with existing and prospective clients, technology has effectively broken geographical barriers by enabling lawyers to to let their target audience know what they are doing and the services that they offer using such tools as customized email setups and distribution lists, albeit with due regard for privacy rights. In the build-up to the 2020 national elections of the NBA, I was asked by one of the media houses whether the legal market in Nigeria is prepared for globalization in view of the fact that lawyering in the 21st century is becoming very sophisticated. In my characteristic candor, I said, the answer to that question is an emphatic no. While I can say with all sense of modesty that from my direct engagement with members of the profession from across the country in the past 18 months, we are now headed on the right track, the reality is that a lot of work yet needs to be done. I have been at the forefront of those advocating for significant improvement in the quality and standard of legal services that we render to our 21st century clients. And I am confident that Nigerian lawyers can certainly meet the desires of a highly sophisticated clientele. But to do that, we must continue to improve on our capacity. One tool that comes in very handy in this regard definitely is technology. I have never missed the opportunity to tell everyone that cares that the current legal education system in Nigeria does not adequately equip the 5,000 lawyers we churn out every year with tools to handle the reality of legal practice in a unique economy such as Nigeria's. As I have said on numerous occasions, if we continue at this rate, the term, the expression, Nigerian trained lawyer may come to connote limitation. God forbid. At the NBA, we're doing our part to promote legal education and mandatory professional development of lawyers. For instance, we have revitalized our Institute of Continuing Legal Education under the leadership of my friend Tobenna Erojikwe to enable Nigerian lawyers, especially the young lawyers, learn, unlearn, and relearn the critical and relevant skills to enable them carve a niche for themselves. And this, the ICLE has already started to do through its robust practice-based training sessions that have been highly commended. Further, in realization of the fact that the legal profession is knowledge-based and research-driven, and having appreciated the need for technology, last year the NBA relaunched the NBA Law Pavilion 2021 package to provide lawyers, young and old, with access to world-class research solution tools which is invaluable in the professional life of any lawyer. This came at the cost of circa 60 million naira to the association. And from the testimony of our members, I am gratified that this has been a very worthy investment. We are going these extra miles because we realize that we live in challenging and extraordinary times, and in a world which is complex, dynamic, and ever-changing. The truth of the matter is that any person, group of persons, profession or field of life that desires to survive must continually adapt and readapt to the changes in society. Otherwise, such a person or profession will be left behind to atrophy and die, and the rest of the world will move on. The legal profession in Nigeria has historically been slow to perceive external threats and slower still to respond to new patterns of service delivery. And it is still characterized by absence of necessary infrastructure and gadgets in the courts, as a result of which most judges are still forced to record proceedings in longhand. Large volumes of law reports, analog filing, and documentation management system, all of which conspire to cause the delay and congestion of cases in courts. For a system that is designed to serve the largest economy in Africa, this is simply not acceptable. We must all lend our voices to the changes that we aspire to see, and without which we cannot survive in this digital age. Thankfully, the judiciary is also fully on board with this message. Sometime in June last year, the Honorable Chief Justice of Nigeria, Dr. Ibrahim Tanko Mohammed, announced that the Nigerian judiciary would embark on a full-scale digital revolution and that would guarantee electronic filing of court processes and virtual delivery of judgments. His Lordship made this announcement while speaking at the opening ceremony of a national workshop for judiciary workers in the information and communication technology space, with the theme Information Technology as a Catalyst for Effective Justice Administration in the 21st Century. Milord, the CJN, while noting that ICT has introduced some radical changes in the legal profession, quote, also implored judges across the Federation to deploy ICT to tackle increased caseload in their dockets because, according to him, ICT is less time-consuming and will fast-track the administration of justice in Nigeria. I must state that the NJC, and I'm a member of that council by virtue of the fact that I'm president, is working and headed in that direction. We have an IT committee of the NJC headed by my Lord, the Chief Judge of Borno State, Justice Zana. And his own state, Borno, have already started e-filing. It's called the NCMS, National Case Management System. E-filing, judges now, he as Chief Judge allocates cases online. The judges receive the cases online. I'm going to be in Maiduguri on the third week in March. We're going to launch fully the e-filing system. So if even the litigators who think that they are immune to technology, a time is coming, or almost here, if you're not tech savvy, and that's where we're going. Bayelsa has rolled out their own their pilot scheme. River State are actually doing theirs without even the NJC. River State they have their Riv Commerce. So, and it's going to be all over. So, I'm sure you all know about legal mail. You need to get a time will come when you need your legal mail to file your cases in court. So I'm just wondering and I'm still encountering lawyers who are saying, I don't have email, send it to my junior. See, if you have it for me, send it to my junior. See, I will send my junior to go and check for me in the business center. In the same vein, the Honorable Chief Justice of Nigeria in December 2021 charged stakeholders on adoption of digital technology for effective and efficient justice service delivery in the country. Milord, who was represented at that event by Justice Zana, the Chief Judge of Borno State, gave the charge while commissioning a digital courtroom for the Federal High Court in Abuja, which is one of the 9 pilot projects undertaken by the National Judicial Council to metamorphose the courts from paper processing to e-filing. It follows from the foregoing, therefore, ladies and gentlemen, that the use of technology is essentially non-negotiable for the continuing survival of the 21st century lawyer. Indeed, the better the technology for the practice and the business of law that a lawyer or firm employs, the better the chances that the lawyer or firm can become dominant because of enhanced service offerings. This also entails, unfortunately, that those who pay lip service to the use of technology may soon find themselves no longer fit for purpose in the legal market. Thankfully, no member of this audience is likely to fall into this category, as your presence here is already indicative of your embrace of, or at least open-mindedness towards the use of technology in the practice of the business of law. I feel like I'm preaching to the converted. So what we need to do is just decide how, like Jesus Christ, we just send each of the disciples from here. And because it is easy to think that the MBA is just about Lagos, but it is not. There are 125 branches. 125 branches. Our profession is large, and you're only as strong as your weakest link. You understand? So the perception of the client, the foreign client, about that lawyer in Cotton Cafe who is unable to respond will rub off on you, the tech whiz kid, because they're just going to say Nigerian lawyers are tech illiterate. You know, that would be the brush with which they will tar all of us. So it's important that we evangelize as far as technology is concerned. Overall, Today's conference will undoubtedly be very worthwhile. Distinguished ladies and gentlemen, I will now happily step aside from this podium and join you in active attention as we hear from and engage our panels on the various ways that we can continue to leverage on technology to enhance legal practice and business. Let me end by congratulating the conveners of this conference for putting it together. I also thank the delegates and the guests who have come from far and near to be part of it. I thank you very much for your attention, and I wish you all very peaceful and fruitful deliberations. Thank you very much.
I'll just go right into the topic and introduce our panelists. We have a very stellar panelist, and some of the people on this lineup are some of my favorite people to interview. So I'm looking forward to the conversation that we're going to have. Of course, the objective of this session is to examine the role of the judiciary, ministries of justice, the bar and bench in the administration of justice. Thank you. Ease of access to justice, automation of the court system, and the overall integrity of our system while leveraging technology for efficiency and productivity. I'm glad that we have a sitting head of courts, the Chief Judge of Ogun State. So please let's rise to our feet and welcome the Chief Judge of Ogun State, Honorable Justice Mosumola Dipelu. Milord, ma. Please keep the applause going till she gets here. Thank you, Milord. Please, Milord, please take the middle seat. Thank you, Milord. I would also like to welcome the representative of the Attorney General of Lagos State, Moyosoro Onigbanjo, Senior Advocate of Nigeria. I understand he's represented by the Surveyor General and DPP Lagos, Solicitor General and DPP Lagos, Ms. Titilayo Shutabe. Please keep the applause going until she gets here. Thank you. You're welcome, ma'am. We also have on this panel the senior partner at Strachan Partners, Senior Advocate of Nigeria, Yemi Kandi Johnson. Thank you, Leonard Silk. Please sit, yes. Thank you. It's also my pleasure to welcome, I understand that Mr. Atoyebi is joining us virtually. Yes? Is Mr. Atoyebi here, or is he joining us virtually? Virtually, okay. So, the managing partner, Omaplex Law Firm, Mr. Atoyebi, Senior Advocate of Nigeria, will be joining us virtually. A round of applause for him. And the last member of the panel, last but not least, the newly minted SAN. I was at the elevation ceremony, Mr. Falabi Kuti, partner, Peckstone and Graves. Thank you for joining us. Yes, please. Yes, please sit next to us. So I will just move closer. Please sit down. Thank you. Okay, I see Mr. Atoyebi online. Thank you. Yes. Thank you, my Lord, for finding time out of your busy schedule to be here. And to every member of the panel, thank you very much for honoring us with your invitation. So I'm going to start straight away with my Lord. Like I said earlier, the objective of this panel is to look at the role of the judiciary, represented by my Lord. Ministries of Justice, we have the Solicitor General here, the DPP. Sorry, the Solicitor General. Yes. The bar and the bench, represented by the Learned Silks, and then Mr. Toyebi online. My Lord, Ma, the feedback from lawyers, and the president of the NBA alluded to it, is that, well, the courts have adopted technology in some ways to leverage on their operations, but there's still a lot of gaps. There's still a lot of complaints about technology, its effectiveness and implementation, especially in the end-to-end e-filing. A lot of complaints about that. And in the areas of virtual court hearings, we find that a lot of our courts are still not using technology as much as they should. It's sparingly used. And yes, e-filing, that one is a major issue. But what also in the areas of court automation, what, my Lord, do you think is the problem? And how can these issues be resolved?
Basically, Basically, in the States, finance is the first challenge that we face. When you talk of technology, it is capital-based. It's not. Is that well, the courts have? It's not something that you can. A chief judge can just wake up one morning and say, yes, I'm going to digitize. When I became the chief judge in 2018, I have a 7-point agenda, one of which is digitization of the judiciary. And because of funds, we have not been able to do much. But thank God, in one way or the other, to COVID-19, we had to wangle our way. During the lockdown, we had a lot of crimes being committed. The police stations were overwhelmed with criminals, and courts were not sitting. And the commissioners of police were going around begging and asking for a way out. And of course, the judges too had judgments that would lapse. Despite lockdown, you would still want to work. And by May of 2020, I had the first practice direction #1 and held a Zoom meeting with all the honorable judges in Ogun State to call them back to work and tell them how to go about it, that we should start virtual sitting with our iPads, our laptops, and our telephones. And thank God, our staff, most of our staff are computer literate. Why? When I became chief judge, I told them that they must be computer literate because their promotion exams, their confirmation exams will be computer-based. So even when you want employment in Ogun State, from the position of a clerical officer, even our drivers take computer-based exams for promotion. And in order to assist them, I also set up a staff development center with 50 computers. And so we train our staff. Thank you. So we train our staff in getting them ready for digitization. And last year, I started thinking of we cannot be left behind. Some of us still do virtual sitting. I do virtual sitting for motions, judgments, rulings. I take virtual, I sit virtually for all those. I have 1 or 2 judges who take most of their cases virtually. My court was equipped by the government for virtual sitting with a counterpart equipment at one of the prisons in Abeokuta. We have. In fact,
I read online that court was boggled at some time.
Yes, but I realized that it's just the TV that was stolen, so it's been replaced. And so with a counterpart equipment at the prison. So the correctional center does not have to bring the defendant to court. Once we are having criminal matters, they will be there. Because one of the problems we had with criminal matters is conveying these inmates to the courts. But now that's almost a thing of the past in Ogun State. We could sit virtually and take these criminal matters. We are really moving forward. And just last year, I thought, what can I do without finance, to go into this e-filing, e-registry, and e-payment. E-payment is very important so that it will save a lot of money. You know, there's always Nigerian factor in everything. There's always the loophole that it's difficult for you to block. But with e-payment, we know that we'll gain a lot. And I called the Law Pavilion people, and they were willing to be in partnership with us. And very soon, we'll be launching our e-filing, e-registry, and e-payment platforms. So that is how far we have been able to go in Ogun State. But I know that like Lagos State and some other states have been able to do it. It depends on the government of that state and how much you're able to get to be able to finance it. Governor is in partnership with us as well. He's always cooperating with us. The initial problem we had was this internet facility, which is very important. But there's this fiber being laid around in Ogun State, and the governor had approved that the Ogun State Judiciary should be connected. And so once we are connected, it's going to be the e-filing, e-registry facility is going to be very easy for us to control.
Thank you so much, Milord. A round of applause for her, please. I want to make a correction. I erroneously introduced the Solicitor General as Solicitor General and DPP. I remember now that Dr. Martins is the DPP for Lagos, and that's a new appointment, so I apologize, ma. And it's good to see you, ma. I'm going to come to you because Milord talked about the role of government, and that's where you come in as a representative of the Attorney General. What is there a clear roadmap that government is working with to ensure that our courts are virtually equipped, that we carry on with this automation of the courts? I know that if you talk to almost all the lawyers in Lagos, they will tell you that e-filing is a major problem in Lagos, even as we speak. So what is the plan? Any clear-cut plans by government? How is the Ministry of Justice, the Attorney General advising the government? And what can you tell us about that?
Thank you very much, Shola. My Lord, good morning, and other panelists and distinguished guests. As you well know, Lagos State government has always leveraged on technology, and without sounding immodest, with my Lord here present, I can say that we are probably the first to start virtual hearing of cases during the national lockdown. Now, to go back to your question, it is very important. It is very important for any government to see technology as a means of transforming services or reforming any kind of institution. The judiciary, for example, in Lagos State, we have the Judiciary Information System, where you can do your e-filing and get your upload your processes, and then you get the case gets assigned a number, a temporary number, and then you follow through with the hard copies, unfortunately. Now, that is an ongoing process. At least that has started. Now, the next level we have gone in Lagos State is to have a plan to digitalize the court system. And we have already started by deploying this technology to 10 courts in the state. And what this is going to do is to transform the way the court proceedings is done in Lagos State. Now it's going to be equipped with screens, court recording system, the ability to transcribe from audio oral to words, and this will expedite the process of getting court records. Normally, it could take up to a month or two. Now, when we deploy this digitalization system, it's going to now take only about 2 to 4 days to get records of proceedings. Also, it will enable the courts to be able to have conferences and also to have virtual hearing, remote sittings, and interview or take evidence from witnesses who are not in the country. This process has already started. We have almost completed equipping 10 courts in Lagos State as the first phase. Also, I just want to add that during the lockdown, the CJ, Chief Judge of Lagos State, Honorable Justice Alugba, also, yes, made the practice direction which enabled us to conduct the proceedings of the court virtually during the lockdown.
Thank you so much, ma'am. Leonard Silk, Mr. Kenneth Johnson, I will come to you. Yes. You heard what the Solicitor General said about what Lagos is doing and the plans. I don't want us to limit this conversation to Lagos because, like the NBA president rightly said, the lawyer in, our weakest link is what will be used to determine how we operate as lawyers. I know that you were at the forefront of pushing for this digitization of court proceedings and court processes and all of that. Are you satisfied with the way that it currently operates in Lagos? And well, even in Lagos, there are challenges, but what did you expect? What are the missing gaps? What have we not done, to ensure that it is seamless and it is working out? What do you find as the gaps and the complaints that we can address, practically speaking?
Thank you very much. It's I've not actually been in the forefront. I have made comments from time to time. I think you find the president of the MBA is in the forefront of digitization, the advancement of digital bar and the profession. But when we're asking these questions, I always like to set context, because unless you know the purpose of a thing, you cannot examine what it's required to do and how it should be improved. So this is the first thing. When we're talking about courts, let me first tell you a small story, then I will tell you what I consider to be the parameters against which we should be discussing. In 1982, two things happened that were significant to me. One was that my university acquired a Lexus computer. This was then a big miracle machine. It was almost as big as a house. Now, it had less computing capacity than my mobile telephone. And in that same year, involved in some little scandal, Lord Denning, who most lawyers should know, had to retire under some sort of a shadow. So I realized that the last time, next year, he wouldn't be sitting. So I left my university and went to London to see Lord Denning sitting in court. And it was quite an experience. 2 QCs arguing before him. His wig was almost black. And the QCs argued this case on their feet for about 20 minutes each. Then the most junior judge went in between both of them. They had a conversation, and then he sat back in his chair, leaned back and said, "Judgment." And then he started speaking for the next 20 minutes, and the judgment was being transcribed. By the time I got back to my university 2 hours later, that judgment was on the computer in 1982. Now, the capacity in that computer and the technology available to the judges in 1982 is in the hands of almost every person in this room. From my phone, I can transcribe proceedings. I have software on my phone which will record what we're saying now and transcribe it into text. And it cost me £10. Now, these are important things when you're talking about capacity. It's if you know what you mean to achieve, that you will deploy the right resources for it. So when you compare, don't compare Nigeria with London or Australia. Compare Lagos State with Kenya, which has a smaller economy than that of Lagos State. Compare Ogun State with Uganda or Lesotho, which has less of an economy than Ogun State. If you go onto their websites, COVID was a miraculous opportunity to advance in leaps and bounds because it was a game changer. It caused people by force to address problems which they had not thought about. They had no choice but to think about, and which technology had come to address. So the short answer for me is that they haven't done enough, but if I might just share something with you without taking too much time, which I consider important parameters. You know, the question of judicial performance is something that is measured by international institutions. You have to be able to know what you're looking for, to know what you want to use technology to address. There are 11 core measures for global judicial performance. 11. 1 is court user satisfaction, the percentage of court users who believe that the court provides procedural justice, accessible, fair, accurate, timely, knowledgeable, and courteous judicial services. 1. 2, access fees, the average court fees paid in civil cases. 3, case clearance rate, the number of outgoing cases as a proportion of the number of incoming cases. 4, on-time case processing, the percentage of cases disposed or otherwise resolved within established timeframes. 5, duration of pretrial custody, the average elapsed time criminal defendants who have not been convicted of a crime are detained awaiting trial. 6, court file integrity, the percentage of case files that can be located and retrieved in a timely manner and meet established standards of accuracy, organization, and completeness. 7, case backlog, the proportion of cases in a court's inventory of pending cases that have exceeded established timeframes or time standards. 8, trial date certainty, the certainty with which important case processing events occur when scheduled, expressed as a proportion of trials that are held when first scheduled. 9, employee engagement, the percentage of employees of a court who, as measured by a court-wide survey, are passionate about their job, committed to the mission of the court, and as a result, put discretionary effort into their work. 10, compliance with court orders, the total amount of payments of monetary penalties, fines, and fees collected by a court or court system, expressed as a proportion of the total amount of monetary penalties ordered by a court in a given period. And 11, cost per case, the average cost of resolving a single case in court, disaggregated by level and location of court and by type. Now, if you set these parameters up and you measure the performance of courts across Nigeria, the record will be dismal, and that includes the Supreme Court of Nigeria, where you can go on an average day and 6 cases will be called and not one will be heard. Basic things like organization of files, producing files in court. These are things that can be addressed by technology but have not. You know, I was in the industrial court 2 days ago, and at 9:30, the generator was switched on. That's not technology, it's having power. It was switched on, and we waited for 30 minutes for the room to cool down. I was drenched with sweat, which made appearing in court of no importance to me anymore. And then these screens came up on the sides and in front of the lawyers. And I thought, wow, you know, this is space age. We can see ourselves. This just seemed to me like a pointless bit of technology, an expensive waste of money. But it's not about the special effects. It's about whether the technology that is available and is affordable has been deployed for the purposes of which courts are established. So this is the test. And you know, judicial services are a public service. You know, I come from a judicial background, so I understand the fancy. You know, even though I find the SAN gowns to be completely ridiculous, I still wear it sometimes. But that's not the purpose. This is a public service delivered to the public as a pillar of government at the cost of the public, and it must be accountable. There must be measures to account. How satisfied? And in Kenya and in Ghana, they do surveys. Forget about South Africa, because this would be regarded as an advanced jurisdiction. So the fact is that there are measures. You can order a lot of equipment at great cost. And I know many of those judges across Nigeria who are involved, I don't want to mention names, who are directly involved in the NJC implementation of digitization. They will tell you privately that much of the deployment is ineffective, it is unnecessarily delayed, and that very often, as in all things Nigerian, corruption is at the root of sabotaging that process. So, and there again, I sit down with the chief judge. I always feel bad when I sit down with chief judges who I know are working. And I know that because very often, judges, when I was in the privileges committee, when we were selecting SANs, the chief judges invariably are not willing to stand up to the Chief Justice of Nigeria or higher judges. And so very often they would come to the senior advocates. So that was on the panel was myself, A.B. Mahmood, J.B. Dowd. This is what we want to do. And then you have to take it up. So if you have a climate where the Chief Justice, whether he knows anything or not, can intimidate the judges below him, that's a problem. So let me not say too much because, yeah. No, she shouldn't speak after me. I'm not putting her on the spot. I don't want her to. I'm just saying, me, as you can see, I'm not even wearing a tie. So I'm ready to retire.
Thank you, Leonard Silk. We won't put Milord on the spot, but it would be interesting to hear her comments on those issues. But I will go to Mr. Toyebi, who is online. Leonard Silk, can you hear me? Hello? Who is online? Leonard Silk, can you hear me?
Yes, I can. Can you also hear me?
Yes, we can. Hello? Who is online? Leonard Silk, can you hear me?
Yes, good morning. Yes, I can. Can you also hear me?
Hello? Who is online? Okay, great. Leonard Silk, I want you to speak to the role of the bar in this digitization process. What can the bar and the litigants themselves do to ensure that digitization works? What can you tell us about the role of the bar and the litigants themselves? Do we go on? Leonard Silk, are you muted? Because we can't hear you. Leonard Silk, I think you need to unmute.
Okay, yeah.
Okay. Mr. Kuti, let me come to you. You are a core litigator. What are the bottlenecks? I know Leonard Silk here has spoken about a lot of it, but what are the bottlenecks that you have experienced with regards to automating the system and also ensuring the integrity of the process. It's one thing to automate the process, and another thing to ensure the integrity of the system. What has been your experience?
Okay, thank you, Shola. Well, let me start by perhaps rehearsing the protocol already established that, and a very good morning, everyone. I would try as much as possible to limit my intervention to the question asked without necessarily rehearsing what has been so eloquently said by Learned Silk, Mr. Kandid Johnson, who, as he spoke, I think he's actually addressed the question you posed to me. I know that all true, but I'll be careful not to be as passionate as to speak truth to power, like he's notable for. So let me just perhaps touch it on the surface.
That's why I asked.
Yeah, you said call litigator. Yeah, you said call litigator. So experience, and I like that. And I would like to just use those phrases, call litigator, and then relate it to what my experience has been in this whole deployment of technology in the justice delivery sector. I practice in Lagos. I mean, largely in Lagos. So to that extent, I would excuse my Lord, the Honorable Chief Judge of Ogun State, identifying ready access to funds to achieve digitalization of the court system. It appears it may not be so with Lagos. I mean, COVID-19 happened. And then I recall that Lagos State being at the forefront of digitalization, but probably this is the third or the fourth year. And well before COVID-19, Lagos State had actually been at that digitalization of the courts, because I recall that some 5 years back, which appears to still be the position as a president, I had to complain to the litigation clerk in the office that was taking too long for him to get matters newly filed assigned to, taken to the admin judge, who would now assign to a court. And I related it to what the experience was like in early 2000. I recall that we filed a matter in 2002, seeking for an ex parte injunction. We filed today. It was to be heard 2 p.m. that same day. But for the fact that the file, a particular process got into the file quietly, they just asked us to come back in the morning. 9 a.m., we heard the application for ex parte injunction was granted by Honorable Justice Yopaye. That was 2002. Now, technology is to ease human activity, intervene in human activity, and perhaps arrest the time span you will ordinarily consume. You ordinarily put in achieving a lot of it. It appears the reverse is the case in Lagos. I am not aware of any new matter that you file in Lagos and you are seeking for an ex parte injunction. When we all know the philosophy behind even preemptive orders generally, that you are seeking ex parte that can get to any court within 2 weeks. I did a research on this, took a census, and at the point I had to go to the registry to find out. So put it this way, it appears technology has now come effectively to take out that provision of the rules that say the court can, in very urgent situations, hear matters and then grant ex parte, because you need to arrest some untoward happening that you've rushed to court to achieve. That is on the one hand. Yes, it is easy to perhaps allude to the fact that there's a whole lot of issues with technology. It would require money, it would require huge capital outlay to digitalize all the courts and all the necessary facilities being put in place. But again, I ask myself that, is that truly the case when or if you decide to perhaps judge by, and I thank Mr. Kandid Johnson for alluding to the parameters, what happened elsewhere in developed climes? Is that truly the case? I don't think so. And I'll give an example. Yes, it takes a lot. It takes a lot of money to be able to achieve all of that. But again, technology has also afforded or availed us some inexpensive ways of achieving a lot of this. The Skype, the Zoom format. I don't think it takes a hammer to be able to achieve that in the laptops or the personal computers of the judges and then the lawyers. And so what it means in effect is that remote hearing, which simply involved the use of telephones and video conferencing to achieve virtual hearing can be achieved without all the hullabaloo about, oh, money has not been released to achieve this, or it's taking this long to achieve this, and all of that. Again, Mr. Kani also referred to what happened in other climes, and I'm tempted to again travel there. April 1, 2020, the UK Supreme Court delivered one significant judgment. The significant judgment touched on something to do with liability, data breach, the possible liability of employers, and Morrison's Incorporated versus various claimants. I mean, it's a judgment that in a recent review by Lord Neuberger, who used to be the president of the court, it will perhaps take another 10 years for that court to perhaps reconvene and perhaps show a different pattern or a different path. Now, that judgment was achieved without one single human interaction, physical activity. April 1, 2020, that judgment was delivered by the Supreme Court. Everything there was done via Zoom. The judges and the participation of the QCs who appeared on opposing sides, the registry of the courts, the case managers, the justices. So, and I come home and I'm wondering that, why can't we achieve, why can't you have something like that, even with all the pretension of doing it? And I recall that in the same 2020, I had a matter before the National Industrial Courts that lasted between then and 2021 for about 8 months. And because of what I felt was an extraordinary achievement in this climb, I was provoked to do a piece. And in doing the piece, I needed to do a research along the line. And what was this piece about? It was the deployment of technology for judgment dissemination. And I call the judgment dissemination the new normal. And in achieving that, I went through the online presence of over 40 Superior Courts of Record in Nigeria. I repeat, all the Superior Courts of Record in Nigeria, they all have websites. But when you go to the website, what you have there sparse information about judicial personnel, judicial divisions, and that just including the Supreme Court of Nigeria. The UK Supreme Court slated a hearing today in a case that is, from indication appeared to be a very significant one in Cramley and Codley. It was meant for hearing 10 today. I'm sure if anybody goes to the UK Supreme Court website, the judgments would have been posted there. That is the same way that is achieved every day. If you go to Bailey, you get to read every single judgment made by the courts in the UK, all the courts, that day. Because I sit with Bailey every Sunday to look through judgment made in the course of the week. And up till Friday, you get to. We don't have that in Nigeria, in any of the Superior Courts of Record, except for 2, the Industrial Court and the Abuja FCTI Court. But then it's not even regularly updated. Now, what does that take? If a court can muzzle the will to have an online presence that posts judicial information, the personnel and all of that, what would it take the IT department or the IT personnel in that court regularly obtaining judgment from the various courts and rulings and uploading online?
Uploading it online.
So, yes, it is true. You need money to achieve quite a number of things. But again, the will would always create a way around to ensure that truly we're achieving what we need to achieve without necessarily finding some excuse for why things are not getting done the way they ordinarily should be.
So without waiting for the funds, there are things that we can do.
There are things that can be done. So the greatest challenge in this part of the world as a litigator is the fact that we've all identified delay in the justice delivery system. That is, on the average, it takes, so I identified the very first one, it takes an average of, conservatively, 3 to 11 years to complete an high court matter in Lagos. On the average, yes. I mean,
Is this the experience of everybody?
We've experienced, yes. I've been involved 3 to 11 years. I've been involved in a matter that was actually meant for an interpretation of instrument, filed through originating summons, no involved hearing, and we're in the 4th year. It's in the Lagos High Court. And I have similar stories and all of that. When I say these things, I'm not saying based on what people tell me. I often tell my colleagues, when it's time to write, I do my research. I don't send people to go get me, so I can defend it that I have these statistics, and I can actually give you particular instances if we were to perhaps come down to the numbers and all of that. So it's worrisome. If we're talking about foreign direct investment coming into Nigeria, every single investor that is going into any new country gets particular about always ask questions about two major things: tax system and the dispute resolution system. How quickly can I access the courts and get judgment if there's a problem? So the justice delivery system here is slow and tortuous.
Leonard Silk, I'm going to come back to you because I want us to get to the interesting part of solutions. Solutions. We all seem to know what the problems are. I want to get to the interesting part, and we don't have a lot of time. But I don't know if Mr. Atoyebi can hear us now so that we can quickly get his perspective. Mr. Atoyebi, can you hear us?
And all of that. So it's worrisome. If we're talking about foreign direct investment coming into Nigeria, every single investor that is going into any new country.
Mr. Atoyebi, if you can hear me, I've been told to tell you to use a corded earpiece. I think the echo is coming from your end. So if you use a corded earpiece, then we won't have this echo and we'll be able to take you. Is it still online? Can you hear us?
If we're talking about foreign direct investment coming into Nigeria, every single investor that is going into any new country.
Atoyebi, if you can hear me, I've been told to tell you to use a corded earpiece. I think the echo is coming from your end. So if you use a corded earpiece, then we won't have...
Okay, I'll try to do that.
Great. So is it still online? Can you hear us?
I can hear.
Okay, so my question is, talking about the role of the bar and even the litigants themselves in ensuring that this digitization works.
If we're talking about every single investor that is going into any new country.
Atoyebi, if you can hear me, I've been told to tell you to use a corded earpiece. I think the echo is coming from your end. Then we won't have...
Okay, I'll try to do that.
Great. Do we move on and then you let us know when we can take him? Okay, great. Milord, I'm going to come back to you. You've listened to what all the panelists have had to say. And I know that you've also said something about the Ogun State Judiciary and the training of support staff, because more often than not, we find that support staff are often ignored in training and then they tend to be the weak link in this whole digitization process. I'm not sure that Milord can speak about support staff of other judiciaries, but we've heard what you said about those in Ogun State. But I also don't know if there's a national master plan, maybe at the NJC, for the training of support staff. What model, what can we learn from even what the Ogun State Judiciary is doing with its support staff? Because you say that there's regular training for them. What can other judiciaries learn from that? What model can we adopt? What is Ogun State Judiciary doing?
Well, as for other judiciaries learning, it depends on funding as well. To train...
We're back to funding.
Yes. You see, we decided to set up the development center because when I started these computer-based exams for appointment and promotion and conversion, we used to take our staff and applicants to either the Polytechnic or the government tech hub, excuse me, and we used to pay. So I sat down and I thought, well, if we're going to do this often, why do we have to pay? Let's set up our own development center with computers. We train our staff. We also have the exams there. So it's going to be capital intensive for somebody to set up staff development center or a place to train their staff, because you will need computers. And buying 50 computers is not a small thing. And of course, the space to use as well. I am lucky to have a space to use because we just moved into a new judiciary complex. We moved there in 2019, and we had space. So I converted a court, a building, 2 courts, a building houses 2 courts. I converted that for the development center. So I did not have any issue of space. I did not have issue of furniture. All I had to do was buy the computers. But if you need to set it up afresh, you need a building, you need to buy furniture, and then the computers, air conditioners. It's going to be very, very capital intensive. And I think it is, let me say in the Southwest, it's only Lagos State that can afford such a thing. So in a way, I can speak for the other judiciaries, at least in the Southwest. So it's not easy for any judiciary to have, unless the government wants to set it up for the judiciary. Since we do not have our financial autonomy, we still depend on the government, so to say. I want to say something about posting of cost lists and judgments and rulings on the website. I think one of the reasons why we don't do that is because lawyers don't like paying fees in courts.
Lawyers.
Yeah, the senior advocates are here, it's true.
Junior lawyers.
They don't like paying. It's every time that, you see, when you want something good, you know that you have to pay for it. I think we just increased, some lawyers were complaining about paying for seal. We have seals for every page of judgments and rulings that you apply for, and they pay for the seal. And they are complaining that it's too expensive. 1 naira 50 kobo for 150 naira, I think, for 1 page. So they are suggesting that we should just put seal maybe on the first and the last pages, and then they just pay 300 naira. And we devised the means of this seal because of fake judgments. And if it is not on every page, you find out that some pages can be doctored. So lawyers don't like paying. If you put these judgments and rulings on the website, some of them will just download and print and may not bother to certify unless it is important that they use it, they certify it before use. We've had occasions where embassies write to the court to verify judgments, and we found out that there were fake judgments. So it is important that we guide this. You cannot compare Nigeria to Britain. Always remember the Nigerian factor in everything we do. There's no matter how much you try to plug the holes of this Nigerian factor, Nigerians are very clever. They will find other means. So that is another problem that we have in this digitization, Nigerian factor.
Well, we're going to take questions from the floor at some point so that the lawyers can also give their feedback about what Milord has said and some of the issues that have been discussed there. Mm-hmm. But Milord, the other question I also wanted to ask is, as some of the panelists have also said, where there are some judges and there's a sitting CJ who is perhaps not proactive with computer, do you find that some judges sometimes, some of your brother judges come to you to say, let's do it this way, let's do it that way?
Thank you. I always tell my colleagues, my chief judges, make use of your judges. make use of your magistrates. When we wanted to start this computer digitization and virtual sitting, I set up a committee, including judges and magistrates. You see, these young ones, they are very, very tech savvy. So I make use of them. I'll call them, go and give me a proposal on this. Call one or two people that you know you can work with, bring this for me. You cannot be the head and do everything. You have to look for people that you think you can use for certain things and use them. I use my judges, I use the magistrates, the JROs. That's the way to go. You want to do something, you can't do it on your own. So when you call them, they bring ideas, and sometimes they come on their, because you are receptive, sometimes they will come on their own and give you ideas. And once you bring an idea, I'll tell you, are you here with a proposal? Say, oh, I just need your nod. Then I'll give you a proposal. And then we set up a committee and we do it. For instance, in Ogun State, we started the Bondsmen Licensing Board to ease out the charge and bill and fake sureties, charge and bill lawyers and fake sureties. And when we started, I set up a committee. The chairman of the committee eventually became the chairman of the licensing board, who is a judge, sitting judge. And we had a seminar, we invited lawyers, we introduced the licensing board to them. One or two of them are also members of the board. And then we advertised and people applied and it's on. So we now sensitize the judges and magistrates. We now have a licensing board. We have people who are registered to stand as sureties. Please, when you are approving bill, make sure that you use these people. And one of the members of the board went for a training in Abuja. And when she mentioned this, some other states that were represented at that training went to her to say, oh, we are coming to Ogun to learn from you, to see how you have done this. Just last week, Kaduna State Judiciary sent a panel to come and learn about this licensing board and how to set it up.
Milord, I want to quickly go, thank you. Milord, I want to quickly go to the issue of, because you've talked about funding and how important it is, I want to quickly go to the issue of financial autonomy. I've spoken to some senior lawyers who say that there must be something that the judiciary can do to get its financial independence. Are we just going to continue and the judges will fold their hands and say, except the funding comes, except there's financial independence? I don't know if Milord is able to speak to this issue of financial independence, the funding of the judiciary, and how it's even going to impact on technology, because like you rightly said, if the adequate funding is not there, then we have not even started.
It is the practice in Nigeria, let me put it that way, that the NBA fights for the bench. There's this saying that judges are to be heard and not to be seen. And in this day and age, things are not the same. We can't keep saying that. That's what I'm trying to say. Things are not the same anymore. What's happened in the past, judges never had to beg. Chief judges never had to beg. When you are comfortable and you are giving your due respect and you get everything that is due to you as at when due, then you can sit back and be seen and not be heard because there's even nothing to say. But when there is something to say, I think we should have a rethink.
Milord, some people would say that radical times call for radical solutions. And I've also heard some lawyers say that perhaps if the judges stop taking the cases of these politicians, and perhaps they would address this issue of judicial autonomy.
I will keep saying one thing. In everything we do here, let us remember the Nigerian factor. You cannot close your eyes to it. It's everywhere. You sit down, you want to plan. I remember when I was a magistrate, magistrates could go on strike. And we had issues, and we called a meeting of magistrates. and then we planned to go on strike. And then we wrote, signed, and sent it to the Honorable Chief Judge at that time. And the next thing, some of us were called, and the Chief Judge was accusing us. So you were seated there, and they were planning to go on strike. You couldn't come and tell me, because some of us had gone ahead to inform him that a letter is coming, and so are planning to go on strike. Part of us, we are all going on strike together, and you have some moles amongst you. So if not for the fact that it is a state thing, and we have more people saying yes to going on strike than those saying no, what could have happened? Maybe some of us would have been asked to go, dismissed or something. So you can't rule out Nigerian factor in all these things unless and until we have executive of even the chief judges. So it's the heads of courts that can take such a decision.
Let's okay, we're going to say something.
Yeah, I was just, thank you. You know, I understand what Her Lordship is saying about the Nigerian factor, but I do not accept the Nigerian factor in anywhere I have power.
You don't accept it?
I won't tolerate my driver telling me he can't come on time when he's supposed to meet me at 7. But I'm not contradicting you, but I'm saying that everything has a solution. First of all, a small problem like the veracity of a judgment. Of course, there's a problem of fake judgments. So what is the solution? 2 simple things come to mind. On the legitimate court site, you can get a copy of the legitimate judgment. That's the end of the fake judgment problem. So that's one aspect. So, and the other solutions, there are all sorts of digital technology for verifying documents. You can say it's very simple. Law Pavilion or any of these law sites, I want to buy a statute from Lagos State government. I pay 1,300, and it comes back with the stamp of Law Pavilion on it on every single page. It's a simple technology. But one thing I want to say about funding is that, you see, I'm not so sure that judiciary in Nigeria is transparent about its use of funds. And that's the problem, because every government function must be transparent. And this is something that will be used by the politicians when they want to deprive. But then if you recognize that the administration of justice is fundamental to the stability of a democracy, then you must fund it. They fund this in Kenya, in Lesotho, in South Africa. Let's not go to the UK. But part of the problem, which seems many people don't understand, is that there is a conscious intimidation and limitation of the judicial function. There's no question about it. There are judges who have been retired for 10 years and have not received their pension.
Yes.
But the Constitution says that if you take this job and you work for 15 years, you will get your salary for life. There are judges who have died, even in Ogun State, without getting their pension. I know this for a fact. Whether the chief judge is willing to say it or not, because you cannot be a chief judge without being a politician of sorts. So I don't expect to say anything.
You see this issue of pensions and stuff. That started happening in Ogun State a few years ago. In the past, it was not the norm. But a few years ago, and I think we have about 6 judges in Ogun State who had retired and have not been paid. And we have been on this issue.
So what you're telling the judges there is become bribe takers because we're not going to pay your pension.
No.
It's a scandal.
It is, but presently,
yes.
You see, the government will keep promising. It happens in Lagos as well.
Of course.
They will promise we'll do this, and then you go and sit down. You become
There are judges in Lagos State who have not been paid their pension. I'm not excluding my own state.
Oh. You see, there's little that the chief judge can do when it comes to this issue of funding, because the money is not with you. If the money is with the judiciary and you don't expend it, then the judges can do something about it. But when the money is not forthcoming, judges, sometimes you will even have to carry your judges and say, okay, let's go and have a meeting with the governor.
Can I just say something before I put this down? Because I caused too much trouble. But the fact is that...
I'm sorry to interrupt.
Yes.
Shola, I think it's about time you took the mic from Lenesen.
Yeah.
Technology. He's putting my CJ on the spot.
Yeah, no, let me leave the CJ. Let me leave a parting word. let me leave a final word that doesn't affect the CJ. In the Supreme Court, basic retrieval of filing and integrity of the filing system is woefully inadequate. I think that the cost of one S-class would take care of the entire filing system of the Supreme Court.
Thank you, Lorenzo.
I'm not saying anything anymore.
Let me come to Solicitor General and the issue of funding, financial autonomy of the judiciary. The CJ has said that if there's no adequate funding, but we've also noticed that in the ministries of justice, and Lagos State Ministry of Justice prides itself as the largest employer of labor, we've also noticed that there's even no automation. Everything is still done with paper, carrying paper to and fro. What is the ministry doing to also ensure that all those is digitized?
Thank you, Shola. That is not correct, entirely correct.
This feedback is from lawyers who interact with the space.
What you just said is not correct. Yes, we still deal with paper, but we have started deploying technology to ensure that we reduce the use of paper and carrying around of files. Let me start by saying that as large as a number of officers are, we ensure that they all have laptops to work with. And if you don't have a laptop or it's broken, for every office, there is a computer, a desktop that you can have access to. And added to that, the Lagos State government generally deployed what is called the Lagos Connect. That is internet available within the secretariat, which you can access at any time. So you can use that to go online to do whatever it is you need to do related to work. Now, for some of our departments, we have deployed what is called EDMS, that is Electronic Document Management System. And this, we upload the task, the file on the system, and from assignment of the tasks to the approval of the Attorney General, up to the approval of the Attorney General, it is done electronically. So the director assigns to the officer treats it online, electronically. It is sent to the director treats it, sent to the PS, and ISO treats it and send it to the Attorney General. And the approval goes back that way, without paper. Okay. That is electronic. That is what we have deployed in some departments.
In the ministry. Thank you, Ma. But Ma, let me get your final thoughts on funding, the issue of funding as regards digitization, the courts, the role of the ministry, and what the Lagos State government is doing, what the Office of the Attorney General and the Ministry of Justice is advising government in this regard.
Well, I can only say that so far, the governor has been very cooperative with the proposal presented by the Honorable Attorney General and Commissioner for Justice with regard to digitalization of the courts. And like I explained earlier, what is being done is to do it in phases because it is capital intensive. Even though we keep saying that Lagos, amongst the Southwest states, probably can afford to do the digitalization, but not in just one full sweep. We need to stagger the funding so as to be able to absorb it and use money to do other things.
Thank you, ma'am.
And I said, we have done 10 about to be completed. And very quickly, I just want to speak to...
Do we know when they will be completed?
Yeah, very soon.
Very soon.
Very soon, but in the next 1 month or so, it will be commissioned. And very quickly, I just want to say that the point that was raised by the Learned Silk about, screen dropping, and it's not about the effects, it's about the impact. In this particular case, it's about the impact. We know that one of the major problems that bedevils the judiciary and causes delay is the fact that judges have to write in longhand. The proceeding is very slow. I mean, how many witnesses can you take in a day writing in longhand? So what this part of the features of this system is automatic recording of proceedings, verbatim recording of proceedings, and transcribing from oral to text. And also, I have given you the other benefits of it. And more importantly also, the records of proceedings will be stored somewhere. It's not like it's going to get destroyed and then we'll have no access to the record like we had recently
when we
in
lost
the unfortunate incident.
the High
Yes,
Court of Lagos.
so that will guide against that. And also the availability of the records will be faster, quicker. Instead of waiting days on hand to have your records transmitted, you will be able to get the records of proceedings, and you need to appeal, then you take necessary steps that you need to take.
Thank you.
And same also goes for the rulings, judgments, and what have you. So definitely it's going to impact. It's about impact, and it's not about what did they call it just now? A
Show. Thank you, ma. That's something to look forward to. Thank you very much, ma. I'm going to round up with you. Thank you, ma. I'm going to round up with you, Mr. Falabi Kuti, SAN. And I want to also get your perspective on solutions. Okay. And Busola already rightly said that we should not continue to rant. We should also look at the role of the bar and the litigants themselves. I want you to, solutions, incorporating the role of the bar, the role of litigants in the use of technology for justice and...
Thank you. I've given us some thoughts. It shouldn't just be about ranting as well. So let me identify 3 possible solutions. First, judiciary itself. The will must be there to explore justice, administration of justice system using perhaps the inexpensive digital platforms that I earlier mentioned, and the commitment to ensuring that, a lot can be done through that whilst we're waiting for the fund. So we start with judiciary. But in saying that, I recognize that the sacred work of a judge does not have that luxury of going to seek for fund on how they have to carry on their work. So it takes us back to the government. Unfortunately, the recent judgment of the Supreme Court does not appear to...
on executive order number 10?
It appears to have left the state's judiciary at the mercy or the pleasure of the governor, the executive. So there's a lot of work that needs to be done in that. And I'm happy that the Attorney General representing the executive is represented here. Now, we come to the bar, and it's good. It's important you identify the bar. I'm very quick to mention Bailey, that Bailey is an online presence that allows you to read everything that comes out of the different courts in the United Kingdom. And then when I did the piece I talked about, and I cited it, some lawyer from the UK actually called to make reference to one little thing that I left out of it, which is the fact that I forgot to mention that Bailey was born out of public interest individuals, public spirited individuals, magic circle firms coming together to set up a trust through which from time to time they can assist the judiciary, for example, in helping to make available the judgment from the court through the use of technology, for example. So the Bailey that I mentioned is actually being hosted not by the bench. I mean, the various courts, the Supreme Court has a website, but the magic circle firms in the UK came together. So that also can happen there. Not just the NBA. Law firms can come together to see ways in which we can assist the work of the judiciary, especially in the use of technology in the justice delivery sector. And there are quite a number of other ways that we can actually think of from time to time beyond heaping the blame on judiciary to see that we get to where we really want it to be.
Thank you so much. Thank you. I think we'll just, I know we are completely out of time, but I just want to take one or two questions from the floor. Okay. Can we have a lady? Okay, good. Can we get the mic to them? I understand the Attorney General of Lagos is here with us. Leonard AG. Is the Attorney General here? Okay, I can see him. Thank you for coming, Leonard AG. So we're going to take a few questions and then maybe we'll get the comments of the AG.
Okay. Good afternoon, everyone. My name is Damilola Momini. It's been a great session today. The reality for me today is that judiciary seems to be slowed down by the reality of political interference in Nigeria. And unfortunately, it has made me realize how much of a dire situation we are in. But I wonder how the NIC does it. Cheap
NSC,
access, the NIC, National Industrial Court.
I thought you said NSC.
NIC, cheap access to justice is the cheapest court in Nigeria. Very fast. The timeline can be predictable. I filed a case 22nd of December 2021 at the High Court in Ikorodu, and I didn't get anything. I didn't get any response. I had to contact someone to help me go through the process. What's the issue? I was told it has to be taken to Ikeja for ADR. I do not want to see how it's going to get there, but I think I had to just intervene. But only for me to get a call 3 days ago, and I was told that at the time I was paid for filing fees of over 10,000 naira, but that one of the critical issues holding my case from proceeding is the fact that a payment of 700 naira was omitted for file. And I was wondering why I didn't get that information through just a phone call. Give me a simple way of making it. I'm told I have to go to Polaris Bank, make the payment. I still have to come back to Ikeja and see how everything would go back. Now that's just 3 days ago. And now, one other issue I've had is the fact
Question, sir.
Yes, but please, if I don't put all of this in context, we will not understand.
All right, go ahead.
One of the other issues I've had with the admission of justice in Nigeria, particularly criminal law practice, is the fact that if you're handling a case and you are so convinced about the fact that in truth and honesty, your clients are innocent, you have a challenge where I feel that the Ministry of Justice is not really strong enough in terms of engaging the police. Most times you hear, we can't get evidence from you except you go to the police. Now the police sometimes they're compromised. What do you do? What channels can you give us? Sometimes leave this fight to us to fight. We'll fight on your behalf. But can you create that channel such that you can be sure of the integrity and that whatever we send through it will get to your table, such that we are able to fight and we are also able to ensure that this is better. So now my question is, how do you want us to join you in making this process better? How do you want us to ensure that we get some level of autonomy for the judiciary? Thank you.
Thank you, Dami. NBA President 2023. Oh, there's no 20. Okay. The question was simple. How do the judiciary and I think the ministries like lawyers to join in the fight to ensure speedy dispensation of justice? Am I correct, Dami? Thank you.
Good afternoon.
Please introduce yourself.
My name is Oluwakemi Oguntoye, and it's been a very enlightening session for me. But I would like to ask a question.
Do you want to direct your question to somebody or general?
I think I'll just make it general.
Okay.
How well does the judiciary and the bar engage other sectors of the economy? For instance, I'll be specific. The CBN has mandated that for every bank to authorize a reversal, whether it was a mistaken payment or a fraudulent payment, there must be a court order. So somebody walks up to me and says, Kemi, I mistakenly transferred 20,000 naira. In my mind, I'm like, can I just give you 10K? Because I know the implication of filing 20,000 naira claim is the same as 2 million naira. So is it possible for the judiciary or the bar to engage the CBN on creating a tech platform where there will be list of documents to upload? you make the payment, and you get your ruling. Because I'd wondered, for me, that 20,000 naira might be insignificant, but trust me, it can be very painful. So, it keeps happening, and it seems as if we are not saying anything. And the CBN is saying you must get a court order. Now you go to the bank and they say, please go and bring a court order. Once you bring a court order, immediately I'll do it for you. So can we have something, even if it's as simple as a doc view platform, a dashboard where you have affidavit of statement of facts, you have evidence of transfer, and then maybe somebody from the bank, maybe a director of operation of that branch, gives a statement of fact, and then the judge in their leisure reviews it and then says, query, this is missing. The person gets the notification in their email, or you see this is done, like just go ahead, okay, approved, and then you download your doc. You can even charge. It's not meant to be free. CSC is not free, but we can do it on our phones. So can we have something like that for specific issues that technology can just solve? Thank you.
Thank you. Kemi, have you lost money in that? You lost 200K. Hey, no wonder. All right, let's get the answers. Mike, let's get the answers. Time is fast spent. We need to move to the next session. A panel session immediately.
Okay.
No, sorry. I'm so sorry. Okay, can you ask the question and then we'll note it and find a way to get it answered before the conference is over? Is that okay? The plan was to have one live question and one online question, and we have had 2 questions live. So having a third question might be a bit far-fetched. Thank you very much. Responses.
Hello. Do you have a question, Ma? Do you have a mic, Ma? Yes, there was a question from the gentleman about Ministry of Justice. How?
Yes, I understand the question to mean that our lawyers should join the Ministry of Justice in the dispensation of criminal justice.
Speedy dispensation.
Well, there's a lot of ways you can do that, but let me first of all clarify that I don't think it's entirely correct to say that Ministry of Justice is unable to retrieve evidence from the police. We work with the police, we collaborate with them when we do criminal cases. They are witnesses, and they normally hand over to us any evidence that is available in the case. So I'm not going to limit my comment to the issue of whether or not we are able to get evidence from the police. It is possible that in isolated cases that you may have come across a counsel saying that in court. Maybe what you are trying to say is that we are unable to bring witnesses to court, not
Evidence I had for the case. The deeds.
Okay, so the thing is, we work with the evidence submitted by the police. The evidence you have, if it was not submitted during investigation of the case, will not form part of the police case file. And that will not be before the DPP. But you are free to bring it to court. That is it. You can bring it to the DPP if you happen to be observing for the complainant, or you can use it if you are a defense counsel. But the most important thing is that a lot of delays that we see in criminal proceedings come from lawyers, defense counsel. Correct. A lot. Once the prosecution is able to close its case, the counsel for the defense, they will deploy any delaying tactics to ensure that the case does not go on. Delay has become a strategy for defense.
Thank you, Ma.
That is what I can say about that. And we need to change our attitude. It's better if we cooperate instead of coming to seek adjournment upon adjournment and postponing the due.
Thank you, ma'am.
Thank
Mr. Falabi Kuti, your final word. Delay comes from people like you.
Well, let me just quickly say that maybe what Solicitor General was saying is that the instance the colleague cited perhaps an isolated one. And I would imagine that there is some complaints channel within the ministry. So perhaps let's also explore that, escalate, see if you can get to the superior. If the Solicitor General is saying that this is not the norm in the ministry, then you face that particular issue, and then which doesn't appear to be norm. Let's escalate it. That's one. Two. Yes. When
I apologize. Yes, there's a complaint channel. You can go online, you can go to our website, you complain and we respond back by email. And if you need to visit our office, we'll tell you to come to visit our office. You can phone in. We have telephone numbers on our website, and I can give you the address www.lagosministryofjustice.org. Thank you.
Thank you.
The second intervention, permit me, Solicitor General, to depart. I would disagree with the suggestion that with criminal proceedings, the delay comes from my experience. I would say that we have a situation where we have a legislation in place, both at the federal and the state level, the ACJL and the CJA, that has come with novel provisions, and those novel provisions, a lot of those provisions, when you look at them, they are not in tandem with the intendment of Section 36 of the Constitution on how best you avail a man who is standing trial and is not to prove his innocence anyway. He's standing trial for in a criminal charge, availing the facility and reasonable time to be able to meet his case. What happened is that you have a law that most times prosecutors now find different sections to hide on, and then the matter can continue to be for God knows how long. And there's a provision that allows them, if midway they are not satisfied with the way it's going, to seek to amend. The law allows them to amend the charge when the matter is reserved for judgment.
Thank you, Leonard Silk.
The provisions of the ACJL, in my humble opinion, is balanced. It's meant to protect. That is the truth.
Thank you,
It protects the defendant and also to ensure that speedy trial, the trial goes on, we have a speedy trial. And don't forget that speedy trial is a constitutional right of the defendant, which he cannot waive. So what we have witnessed is that defense counsel, they find other ways, not coming to court, seeking adjournment for flimsy reasons, or filing frivolous applications every now and then, anything just to stall the trial.
Time. Thank you, Ma. Thank you, Ma. We've completely run out of time. Leonard Silk, your final words, and then I'll get final words.
Yeah, the only final word is that this.
There was another question, and you seem to be agreeing with the young lady who was talking about.
Oh yes, well, okay, I was, because it's about proceduralization. The fact is that both the bar and the bench have a responsibility in the administration of justice. They should both work to achieving a result that is accessible, that is fair, that is obviously fair to members of the public. This is how you inspire confidence. But you were, in granular terms, you were referring to a simple procedure. First of all, I find it ridiculous you need a court order to reverse a wrongful debit in account. The Central Bank of Nigeria should have its own online dispute resolution process, which can take 20 minutes. This is a 20-minute case. It's a waste of time bringing this to a judge. Waste of paper, waste of time. But you proceduralize legal processes. You're talking about ticking off boxes. You know what is going to, you know that in the landlord and tenant cases, there are no more than 10 issues that need to be established. You know that in the debt case, there are key issues. You identify them, you make the lawyers do the work before they come to court. There's no point coming to court and dumping the case on the judges and then blaming them. The Ministry of Justice must do the criminal work before they file any case. A lawyer bringing a civil case must have done the work before it comes to court. For example, when we did backlog elimination review in 2018 in Lagos, we found that 80% of the cases that were delayed were land cases. And what caused 90% of the delays? Absence of survey plan. So why do you accept a case for filing when they haven't bothered to get a survey plan? It's very simple. So you create a pre-action protocol. You cannot file an action unless the following documents are there. Once those documents are there, a first-year law student will tell you, this case is to be dismissed. And judges ought to be confident enough to strike out cases that are on their face incompetent. Whether they're going to say that I'm from Ogun State and that man's is from Ondo State, you're going to be assaulted. If you're in leadership, they're going to abuse you anyway. But if you're doing your job, you don't care.
Thank you. Your final words, my lord. And the question about what we can do to help the judiciary.
What you can do to help the judiciary, I was whispering to my brother here that the person who asked the question is one of the young lawyers, that you should see the senior lawyers. They know what they're supposed to do. And what I was going to say is to plead with the NBA not to leave the judiciary to fight our cause. Without the judges being comfortable and ready to work, you cannot make money. You cannot make, if you are not comfortable, if you are not willing to work, if you are not ready to work, you just come to court and I say, take a date. You start grumbling. You come the next time and I tell you, take a date. That's one way of protesting that come to our aid. So I am using this medium to appeal to the NBA. Thank God the president is here to come to the aid of the judiciary. Don't leave us at the mercy of the government. Thank you.
Thank you, my lord. Thank you. Thank you to all the members of this panel. Are we able to get Mr. Atoyebi?
Yes. Can we get Mr. Atoyebi, SAN, to
just give us a brief comment?
Comment? Is it with us? Is it with us? Is it with us? Is it with us? Is it with us?
In a subsequent panel. So on that note, I want to thank every member of this panel. Thank you, my lord. Thank you for your time. Thank you, Leonard Self. Thank you, Solicitor General. And let me bring the Attorney General of Lagos up briefly since the AG is here, so that he can say one or two things about the theme of this conference and the intervention of the Ministry of Justice. Thank you.
Please, a round of applause for the Attorney General of Lagos State. Please, we would like to take, please. Hello, 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 hello.
No doubt that our profession is in dire straits. And if we do not adopt technology, we're going to die off. And so, whether in public or private practice, technology is the way to go to make processes easier. Technology also affords transparency in all that we do. There's a lot of mistrust between citizens and government. And one thing technology would do for all of us is to let the citizens see from the onset what government is doing. So it seems as if sometimes there's no motion, there's no traction from government side. But the way I see it is that there's been a systemic rot from way back. And fixing this rot, sometimes it appears as if you're just running on the same spot. So there are problems plaguing almost every facet of the administration of justice, from the public sector, from the judiciary, even in private practice. We need to, quickly devise ways and means of overcoming all these challenges. But one sector cannot do it on its own. The judiciary cannot do it on their own. Neither than the public sector, Ministry of Justice in this case, we also cannot do it. The bar also cannot do it. We need to come together and agree on certain principles going forward. This kind of session that we've had this morning is geared in that direction. And that's why after attending some representational duty this morning, that's why I decided to stop. I was sitting back there quietly, enjoying the conversation and enjoying as my permanent secretary was put in the spotlight. So, there's so many things we can all do, but you can be rest assured that on our part, we embrace technology, we welcome it, we will deploy it. But of course, in economics, everything depends on how far can you stretch the resources. So when you don't perhaps have somebody who has practiced law, governing most cities, most states and governing the country, they don't appreciate these issues as a lawyer who is in practice would appreciate them. And as such, in sharing resources, there is no doubt that the judiciary, the administration of justice, gets the back end of it. We don't get enough funds. We don't have enough funds to do all the lofty programs, all the lofty ideals that you guys suggest to us. There are not enough funds to do everything. But bit by bit, be sure that we are ticking each box as we can. We try to deal with the low-hanging fruits, such as digitalizing the courts, such as going paperless, such as, being more open, letting people see what we're doing. And time is fast spent, no time to fully elaborate. Much has been said by the PS and all the panelists. And just here to thank you all for your contributions. We'll take them on board. We are welcome to change from, the past, and also to render better quality services so that rather than criticism all the time, we can also have one or two commendations. Thank you all very much.
Thank you, sir. We have a ministry that is open to suggestions, as the AG puts it there. So we'll take a quick picture and presentation of gifts, and thereafter we'll go straight into the next session, which I believe every lawyer present will be glad that they attended or listened to. Can we have the NBA president for pictures? Thank you. You see, they are networking up here. Where you are to please network your own network. Busola convener, if you don't mind, could you just stay in the middle? Yes. Convener. Okay. President. What's the presidency? Okay. All right. Where's the photographer? Over there, sir. That's ma'am. That's the photo. Are you ready? Please, every other person can take pictures too. What are you saying? I should move away. No, let me balance this part. 1, 2, 3, 4. 1, 2, 3, 4. Balance. Blue suit, blue suit. Photographer Alpha. Thank you. Thank you. All right. Please, we have gifts for you. I'd ask that all of us seated, please take your own pictures too and put me inside. Whilst give a round of applause one more time for the panelists. But then please do take a picture of yourself wherever you're seated. Thank you, sirs and my lord. Thank you so much. And ensure to tag or mention SLB on socials as you post. The handles. Thank you, Leonard Silk. Thank you so much. Thank you, PS and Solicitor General, Lagos State. Thank you. Thank you, Mr. Yemi Kandi Johnson, Senior Advocate of Nigeria. Thank you, the Distinguished Attorney General and Commissioner for Justice of Lagos State. Thank you so much, ma'am. Thank you to my lord, the CJ of Ogun State. And thank you. Please, how many of us believe our moderator did an awesome job? Please, a round of applause for Shola. Thank you. Oh, we have a gift for the NBA president as well. Thank you. Ma, you can't go with also. Okay. Yes, please, once again, a round of applause for the Chief Judge of Ogun State. Indeed, she came in from Abeokuta this morning and she was here before 8:30 because I was here when please, thank you so much for gracing this occasion with your presence and of course for letting us know the limitations that there are with the judiciary. Please, the conference is not over. I would like to quickly call the moderator for the next panel session. The topic of the next panel session is optimize, automate, and boost legal operations for efficiency and productivity.